The following program is suitable for general audience of any age.
Tonight, we discuss the legal landscape relating to breach of promise of marriage. How does the law view these issues in the current digital context? A very good evening and thank you for joining us on yet another episode of Law, Land and Liberty, where we bring to you key legal concepts and break it down for the layman. Today's topic is something that we have previously touched on very briefly, but we haven't been able to get into much detail on it, and that's on marriage and breach of promise of marriage. Specifically in a time such as these, especially in current times when the online sphere is dominating the actual actions that occur during relationships and marriages of all, we have to get some clarity and understanding exactly where the law draws the line when it comes to the breaches of promise of marriage, and also what exactly that entire area of law consists of. To speak about this, we have someone that's not a new face on the program and will be very much equipped to explain to us and help us understand. That is Mr. Ian Fernando, attorney at law. So thank you so much for coming back to the program. It's been quite some time since we've had you.
It's my pleasure.
Absolute pleasure to have you, sir. Of course, this is how we're going to be going about. For this discussion, we'll be getting into the fundamentals and basics, trying to understand what exactly promise of marriage and breach of these promise of marriage means. Next, we'll be getting into the practical examples and the history when it comes to case laws and context, how exactly the courts have treated this. And finally, we'll be talking about what we can expect as reforms, amendments, the future, and so forth.
Hello, my name is Geetika and I'm a creative producer. My question is on the fundamentals. What are the laws that are governing the breach of promise of marriage?
All right, well, without any further ado, let's get right into this discussion. Once again, thank you very much, sir. We have quite a bit of area to cover specifically because this is not a singular piece of legislation, but rather it's concisely. We have been carrying this topic with you previously for about the past few months as well. Before we get to the legal specifics, can you help us understand what exactly a breach of promise marriage is? What is the law behind that? And if we can get a good understanding, an introductory context, it would be appreciated.
Anuradhi, with the Valentine's Day coming around the corner, being the 14th of February, I'm sure so many promises of marriage must be made by several people. And gone are the days that we would give chocolates and love letters and roses for Valentine's Day. Now we are in an electronical age where tech gifts are given. SMS messages, WhatsApp messages, all that type of thing has now come into play. So a breach of promise of marriage as construed in our law, according to the General Manager's Ordinance, which is in 1907 as amended up to now, at section 19 and 20, specifically 20, sets out very clearly that the promise to marry should be in writing. If there is no promise to marry in writing, that cannot be termed a valid contract or a promise. For a promise to be made in writing, there has to be an offer by the one party who wants to get married, and there also has to be an acceptance. So those two ingredients, even by text or those days by love letters, there must be a mutual understanding to create a legal relationship to get married, which is an official contract.
Can you help us understand, now that we know that foundationally there is a key piece of information that it needs to be communicated in writing in order to ensure that there is a proper promise in place. Legally, could you help us understand what exactly are the pieces of legislation that govern breach of marriage, promise of marriage, specifically now the marriage registration ordinance is something that we can draw attention to. Can you help us understand how exactly the law sets it out?
Yeah, so far back as in 1 ACR 903 in Billing versus Veethakan, the case set out that the verbal promise to marry under section 20 of the Act must be corroborated by a written piece of evidence. Now, when you say that You can't say, I will marry you and no one else. You can't make a promise of that nature, because that is not a valid promise. You have to make a promise to that person to get married, and that promise, according to our marriages ordinance, can be by betrothal, which we have, which is exchanging two letters. On the engagement day, some Catholics, they exchange letters on a note that they are going to get married. So that exchanging of two letters make an offer and acceptance relationship, and there's the intention to create a legal relationship called marriage. So that has to be reduced to writing. You cannot say, I will marry you and no one else. That's not an offer. That's not a proper offer.
If there is no proper offer, it doesn't constitute a breach of a promise. I want to ask you, moving on, sir, specifically relating to, now you mentioned some of the case law as well, but there's always a question in how Sri Lankan law historically has approached this breach of promise of marriage, because it's not that it's something that has just popped up recently. We've had it consistently, as you mentioned. Back then it was letters, now it's in text. So how exactly has that translated in modern days specifically, very much because we are all in the online sphere, and maybe the laws have lapses when it comes to specific situations of the current day?
No, I would say context, put this in this manner. The law has developed on the question of breach of promise of marriage, and the recent judgment in the Democratic Socialist Republic of Sri Lanka in Court of Appeal in case number CA/633/97F, an appeal from the District Court of Matale, 4677 MB, Justices A.H.M.D. Nawaz, Honorable Judges, and H.C.J. Madavala, Honorable Judge, has held that when you are making a marriage promise and you are sued that the marriage promise did not fall in line for a sum of rupees 100,000 as damages, the judges went on to see the findings in the case and found out that the person who made that offer to get married was a married man. So a married man who is already contractual with another person who has contracted a marriage cannot make another marriage, because it becomes a bigamous marriage. And for a bigamous marriage, in our law, there is specific provision that you can be prosecuted in the magistrate's court, and fine can be given for a bigamous marriage. So even to make an offer of that nature to get married is not having the legal status for the married person to say, I love you and I am going to get married to you. It will not suffice. So in that judgment, the latest judgment which I could lay my hand on, which also they followed the principle set out in Chandrasena versus Karnavati in 57 New Law Report, page 298. The documentary evidence and the oral evidence, it was there about the marriage, but however, they did not have the legal status quo, the legality to be able to give a promise of marriage, being a married person. So to all married people, you can say, I love you on February 14th, which won't mean anything because you are legally married.
Yes, and conversely, sir, now this is of course on the breach of a promise of marriage, but of course we need to understand if there are instances where the law can compel marriage between two individuals. Can you help us understand in that area how exactly the law has written?
Yes, if you have given a specific date on which you are going to get married, a specific date relating to that by the 14th of February I am going to get married in 2026, and you do not get married, then there is a recourse for you in the district court, not in the magistrate's court, for specific performance under law of contract, specifically to perform this act. You have given a promise and there is a contract and there is specific performance now for you to contract the marriage. So an order can be given in that way for you to specifically perform such a thing in terms of section 20 subsection 1 of the marriage registration ordinance. But you can't force someone who has agreed to marry without giving a date and time and place if he rescinds on the contract of marriage. So coming back to the question of specific performance, though in a law of contracts, when there is offer and acceptance on any contract, you can embody it in court in the civil code. This type of contract, offer and acceptance of a marriage, you cannot contract for specific performance in court, because court can't ask two people to get married when they don't want to get married. And in doing that, first you have to check in your contract with the other party whether he has given a specific date on which he or she is going to get married. If you say, I am going to get married and give no specific date, that's not a sufficient offer for a person nor acceptance, and you can't go into the question of breach of promise of marriage. Courts have held that if the breach of promise of marriage is broken, for example, you print the visiting card, the invitation cards. Invitation cards are sent out. Then there is a date put on the invitation on which date you should get married. So if you break that, then there is a good grounds for you to go for a court case in the district court, not in a criminal manner, and ask for contractual liabilities and delictual liabilities. Now those contractual liabilities are the amount of money you have spent to find the hotel, to book the band, to have the host, all the paraphernalia of dancing troops taking part at the wedding. That is the contractual obligation on damages. The delictual damages are the pain of mind that was caused to you due to the non-performance of the marriage. So there are two limbs that you can go to district court on, asking for damages when a promise to marry has been made and has been violated by either party.
A question that arises when it comes to the aggrieved person, when it comes to a breach of promise of marriage, because of course it's not amicable, which is why we are in this situation in the first place. What other types of damages, according to the history that courts have given us, apart from delictual damages and contractual damages that can be claimed, is there any other instances where the courts have posed some sort of justification for the other party, or is it simply only these two aspects that are available for as remedies?
These are the only two aspects which are allowed as remedies. As you've seen in that last judgment that I cited to you, that was a married person and he was not entitled to damages. So the courts only will conform itself to the delictual and contractual damages. For examples, now if you take a promise wherein properties are transferred to you in contemplation of marriage, that is called donatus causa in the Latin term, that is given in expectation that you are going to get married to my daughter or son or whatever it is, and the marriage doesn't take place. Now in that scenario, you can file action to get the property or whatever you are given back, because there is no case where both can show that they are legally married, and that was a condition precedent to their marriage, and if the marriage has not taken place, you can ask for the property back. So parents who are wanting to give their children in marriage, when they try to give by property before they get married, have all the right to take back the property once the marriage has not gone through. And as I mentioned earlier, this promise of marriage, which is called the betrothal, exchanging of letters, there is this nakat paper also given by both parties. Those are the special nakat paper. It doesn't say exactly that you are going to marry that person. It's only finding out a nakata. But you will have to go further to corroborate that evidence by the nakat time and all the nakat paper, that there was going to be an intention to get married on a particular date. That verbal evidence must be corroborated in writing according to section 19 and 20 of the Marriages Ordinance.
A very important question that I have relating to breach of promise of marriage is when is it considered that there is no valid, there's no actual breach of a promise of marriage, or any valid excuses that could be mentioned?
Now, if you take section 15 and 16 of our Marriage Registration Ordinance, it gives a prohibition decrees of marriage, wherein, say for example, two sisters, Their children, if they are a boy and a girl, if they get married, those are prohibition degrees of marriage. Because medically also, if you get married in that manner, you can have a child which is not normal. So those prohibition degrees have been set out in section 15 and 16 very clearly on the half blood, on the full blood, how the descendants cannot get married. So that is a grounds. Now I can show you that when you are getting give a breach of promise of marriage in a situation of that, you can say that that is not having the proper status to get married. Or you are under 18. Between 16 and 18 years, you have to get the parental permission to get married. I am told recently that even the Muslim law, they are going to bring it to 18. There are amendments to the law of their marriages. After 18, anyone can make his or her own will to get married to the other spouse, and that will be a proper offer if it doesn't fall within the prohibition degrees of the marriage. And also if you are not a married person.
The requirements for the validity of confirming that a breach of promise has occurred. I want to get now, of course, previously we had this conversation relating to the factors that will consider that there is a promise which has been breached. But I want to ask you, sir, relating to other external features that we can see that contributes to the actual promise being breached. Now, there's always that confusion as well as we already know, even wedding invitations, they're not sent by post anymore. A lot of communication occurs through social media channels and all of those. So when it comes to our current context, there's always questions and lapses relating to how exactly an individual can determine if there is in black and white a proper promise of marriage. But we do have to take a short commercial break because we're running out of time in this segment. So please do stick around for all of that information when we get right back after this. You're watching Law, Land and Liberty. We'll be right back. Stay tuned.
Hello, my name is Anjana and I'm an undergraduate. My question is on practicalities. What amounts to a proper promise of marriage?
Welcome back to Law, Land and Liberty. We're in conversation with Mr. Ian Fernando, attorney at law. We were just getting down on the basics of the breach of promise of marriage and the legal areas, how exactly to understand when there's a breach occurring and if there was a valid promise that has been created in the outright. Thank you very much, sir, for the previous segment. I believe we were able to get some foundational understanding into where the law is when it comes to this area. But now, before we left off into the break, I wanted to get to the specifics relating to our current context, the practicalities when it comes to the modern digital age. Apart from the fact that it needs to be in clear writing, are there any other pieces of evidence when it comes to the current context with the digital age for the formation of an actual promise of marriage? Can you help us understand?
Anurad, you are correct. Now, if you take the case of Gunasekara versus Amarasinghe in 1993, one Sri Lanka law report at page 170, they have considered that if you have a series of events that show that there is going to be a marriage on a particular date, corroborated with the evidence in writing. Now, what you are asking is a SMS or a WhatsApp message that can be construed to be a valid promise if you are given the date on which you are going to get married and it is accepted. It is like you earlier used to give it in writing at the time of the betrothal. Now, with the digital age, it has increased that we hardly send anything in writing, everything is sent on computer or by SMS or by WhatsApp message or by MMS. So, taking into the advancement of technology, it is another source that you are using. Like those days we had letters and we had telegraphic messages. They amount both to the same. But in the case of electronic evidence, you will have to come within the norms of the Act, the Special Provisions Evidence Ordinance Act and the Electronics Electronics Transactions Act. You have to conform with those to see that You have not duped some machine or some phone to send that message. It has been an authentic message sent by that person. So if that amount of evidence can be corroborated, you know how many times that your computer might be filtered by someone else, or your phone is taken and someone has sent a message, then that will not suffice. You have to make sure that it has been sent by you. So if it has been sent by that person to another person, the electronic media covers that a proper offer and acceptance has been made, and therefore there is a date specified for them by which they need to get married. Just transferring properties and also saying I love you and send you bouquets of flowers don't constitute a legal promise to marry.
Well, the evidentiary aspect is something I want to get a little bit more into, relating to what you just mentioned as well. So now letters and telegraphs, they were mentioned, but when it comes to things like letters of affection or maybe declarations, as you mentioned, bouquets and other gifts, they don't constitute towards an actual promise of marriage. Are there instances where it does actually corroborate or hold up to an already existing promise of marriage, or are they completely irrelevant?
Even sending a card, Valentine's card as it's called today, or a card showing your love with a heart in the middle, doesn't show a valid promise of marriage. It only says that you are in love with a person. Being in love with a person, Anuradhi, and getting married are two different things. You can be in love with several people but only get married to one. So that connotation of sending text messages and WhatsApp messages and sending cards and all that only constitute that you love thy neighbor as it called, but it's not a valid promise of marriage.
The external factors is also something that we have to consider, because a marriage, of course, it's not just a union between two individuals. There's multiple, the families and all the other people that are related that might be, doing an effort in the union in itself. Does witness testimony or any other testimonies, tertiary accounts, do they contribute towards solidifying if there was a promise of marriage in the first place or no?
No, because that is not sufficient evidence. But if you take a situation like this, which you see every day, you are dating a girl and she has become pregnant. She is between the ages of 16 and 18. If she is under 16, you will be caught for statutory rape. Even if you dated her and had any movement with her, I put it in those words, you will be called for rape, even if she has consented. Then if you are coming between the 16 and 18 group and she is pregnant now, what the lawyers normally do is make sure that they get married with the consent of the parents. Between 16 and 18, you have to have the consent of the parents. And once the child is delivered and they are married, and if they think that they can't get on with each other after 18, then they file a divorce case. So you see how well they have taken the law into their hands, but got their job done, because you have pregnated a girl under 18 over 16. Now that's circumstantial evidence. There are DNA tests today. The DNA tests, there are so many areas, the DNA that they go to find out. For examples, even if you can check the pubic hair that you have, if it is with the male's pubic hair, they can comb the pubic hair and find out who has really done the rape. So the science goes that far. So with the DNA also, they can find out that you are the culprit. Then the next question is, you asked to marry the girl. And after that marriage, if they don't see eye to eye, then they can go in for a divorce. So that's what you call a circumstantial situation, where the breach of promise of marriage doesn't take place, the marriage has taken place, but you get out of the mess that you have created.
How exactly now, specifically relating to now as you mentioned, sir, there are areas where certain ways that the law is already poised will allow for individuals to navigate the law in such a way that is less threatening. Do you believe that right now the marriage laws that we have in the country are airtight, or is there a necessity for changes specifically in this area, specifically when it comes to marriage, breach of promise of marriage, but also marriage laws in general?
Taking account in the European sector, where they fall in love at a very early age and they start living together, then there is no question about breach of promise of marriage. It is a marriage which is called by habit and repute. The people understand that you are dating so and so and you are going out with so and so. So there is no promise of marriage. There is no promise of marriage. They are living together. In the same way, our Hindu custody systems, when they had their marriages, if they were not registered, they would put the thali on, the thali. That should constitute a customary marriage. So even in Sri Lanka, we had customary marriages wherein no registration, no breach of promise of marriage can be filed. But they were living together happily, and in the old Canadian times, they were living together with the Diga and the Binna marriages, as they call it, but no marriage was registered. So just because you are to have a breach of promise of marriage, basically there is no breach if you are living together. If you are living together or living separately and having the same idea together also, Anuradhi, you will fall into the same category. There is no breach. But as you specify a date and your willingness to get married before a particular date, then you are in trouble.
Now, there's also a question where what if there was a written promise or written testimony that this promise is existent and there was a date, but the document was lost in some way. Maybe there was no other copy of it, but of course there are individuals that can give testimony to the fact that there was a promise, a written promise.
Yes.
How exactly does the law deal with that area?
That was also set out in that case Gunasekara versus Amarasinghe in 1993, 1 SLR page 170. They had lost the document, but they said there was a document in writing, but testimony was given in court regarding the promise to marry.
So,
right. So that was considered to be a breach of promise. Though the written document was not there, the circumstantial evidence showed that though the letter or the document was lost, that culminated events showed very clearly that there was a marriage promise between parties. So then therefore you are entitled to damages in that scenario.
So relating now, as you just mentioned, testimony did play some role when it comes to already existing written promises. But is there also an area where the law considers that now with established correspondence, can that also count towards an already enforceable promise?
Yes, the enforceable correspondence between two parties, the golden stem that runs through that correspondence is, whether it's electronically or written or whatever, that a date must be given on which you are going to get married. If there is no date, whatever you write, as I mentioned, I love you, you love me, we all love each other, won't help.
There has to be a certainty.
Indeed.
Before we move on towards the future aspects and what we can expect to see as developments in this law, I want to ask you relating to the practical approaches for understanding the written promises versus oral promises. Now, as you mentioned, clearly written is the law. Specifically, correct, there needs to be correct, a written promise. But how exactly have courts treated oral promises? Maybe there were dates mentioned in conversations or correspondence. How exactly has the law set out to define that, is it completely useless? Does it count towards something? What exactly does that area look like?
The law has not developed, but Section 40 of our marriage ordinance says, even on the deathbed, you can get married. So basically, if you are having a promise to marry and you couldn't fulfill it all this while, Section 40 is a loophole. If you are so keen, on your deathbed you can do your marriage, and in that circumstances no notice should be given. No notice should be given. The solemnizing priest or whoever, the registrar, is not necessary to give any reason, because you are on your deathbed going to fulfill the promise of marriage. In the other scenarios, you have to give the notice. You can get married otherwise under special license. Special license set out in the act, you can get married. Otherwise, you have to give the notice of marriage. And when you give the notice of marriage, anyone who has a problem in that marriage can come and object before the Register of Marriages. So those impediments are there when you give a promise to marry, unless you are straight and clear about your marriage with nothing else coming in between.
So that means essentially, despite correspondence, oral promises will not have as much precedence, apart from the fact that if there was already an existing promise of marriage and in a precarious situation, there's still an ability without notice to actually carry that forward. There is a bit of area I want to get clarity on relating to what we can see now in the current context, and also what we can expect to see moving forward as well, relating to the legislature and also the environment that the legislature is applied in Sri Lanka right now in the current context. But before we get to any of those specifics, we do have to take a short commercial break. We'll be right back after this with the final segment on law, land and liberty. Stay tuned. We'll be right back.
Hello, my name is Hiruthi Nithya. I'm an Associate Software Engineer at HCL Tech. My question is on the future. How can we expect developments to occur in this field? Thank you.
Welcome back to Law, Land and Liberty. We're in conversation with Mr. Ian Fernando, attorney at law. We were just discussing the basics of a breach of promise of marriage and understanding the legal reality relating to this practical concept. Thank you very much, sir, for the previous two segments. Unfortunately, we are running out of time. This is our final segment. I wanted to ask you relating to some of the more specifics on oral communication and filing a legal action relating to a breach of promise of marriage. But before that, how about we start off this specific segment with an understanding of what exactly has changed over the past few years when it comes to this area of the law, and what are the latest developments as you have seen in your experience, and if we can expect to see developments and amendments moving forward.
Yes, as you see, recent past, there is so much legislature that is coming in. For example, we are still awaiting to see the Rent Act being overhauled or removed fully. It's yet to come. Now we have been made to understand that there are three grounds for divorce. One is adultery, other one is malicious desertion, construction or otherwise, constructive or otherwise. Another one is impotency, sexual impotency, which is incurable. I'm told now it's been discussed in the legal circles to add a fourth, that is, parties of consent can get divorced. So that means that you don't come into the category 1 of adultery, or category 2 of malicious desertion, or category 3 of impotency. You come into a new area called mutual consent. Now, then there won't be any breach of promise of marriage. That will go overboard, because parties are agreeing at any time to get married, and any time of mutual consent they can fall apart. And we have this thing called the prenuptial contract, where in Sri Lanka we don't see it happening much, but the law provides. I checked up even from a lecturer, with an eminent lecturer at law college. He told me that prenuptial agreements are pursuance can be done by prenuptial contracts, where we enter into contracts that in the case we get divorced, our properties will be divided in this way, or I will not be asking for your property, or you will not be asking for our property. So coming into that light also, with the prenuptial contracts, if as more contracts of that nature, getting married and departing company, as they call it, will be much simpler. And the new law that is envisaged that they are going to have by mutual consent, that they want to part each other's company, will have and see lesser cases of breach of promise of marriage. Because love at first sight, as they call it, you can get married, and if you tomorrow decide that you don't match each other, with mutual consent you can go and divorce. But if there is one party who really wants you for the rest of her or his life, then you will have to go through the normal district court procedure and get your marriage annulled, which is called divorce vinculably, and get that cause of action for divorce from the district court of Colombo. And by chance you have entered into the decree nisi, that's the first instance of the divorce case, but your decree nisi has not been made decree absolute, which takes 3 months. And if you get married in that 3 months time, that's in limbo, you again will be caught for bigamy. So many people think that the case is over, on the decree nisi day they go and get married after that. But decree absolute is not made. That 3-month period is set out in our law that you cannot get married to anyone else. Only decree absolute is passed and the judge has signed the papers, only you can make an offer to any lady or vice versa to get married.
The question that arises when it comes to this specific area is, we were able to talk about the legal components, but how exactly does one go about filing a case or taking legal action against a breach of promise of marriage? What does that process look like, sir?
That process is normally contractual or delictual liability. It's a normal case for damages, where you will have to send a letter of demand first. In any damages case, under our common law, you have to give notice, and in damages case, our notice is of 14 days. We are asking that person to pay the damages within 14 days. If you are a shrewd and sharp lawyer, you might send the letter of demand asking them for damages to be paid within 14 days. Also, you might put a rider saying that if you do not reply this letter within 7 days from the receipt of this letter, I am made to understand, or my client is made to understand, that the contents of the letter of demand are perfectly correct. Then you put the ball on the other person's court for him to play it, because he can't just put the letter of demand in the dustbin and ask you to prove it in court. He is compelled to reply your letter within 7 days. For example, you are given a case on breach of promise of marriage and you have the date, and you say that you are claiming delictual liability of 500,000, contractual liability of 1 million, and setting out the circumstances in which that the marriage was to take place on this date, and there was a letter in writing or invitations printed, and therefore you are entitled to, since the marriage didn't take place. Then if you write a letter stating that within 7 days you have to reply, otherwise you are deemed to note that the facts set out in the letter of demand are correct, you will definitely get that answer for that. And before you file a court case as the plaintiff and the plaintiff, you will know his answer beforehand. So that is a very wise way of writing a letter of demand.
When it comes to damages, on a related note, sir, are there instances where the courts have been able to negotiate for a reduced number of damages? Is there instances where maybe there is some sort of agreement that has been made amicably, or, well, not amicably, but rather in better faith? How exactly do the courts navigate that? Is it always a harsh penalty?
Contractual damages can be set out to have the facts and figures of the hotel and the what have you spent on the wedding suits and the band that is going to play and the dancers who are going to dance. But when it comes to the other part, delictual liabilities, it is your pain of mind, the social standing in society, the loss of face that has caused by that particular party not getting married to you, the mental trauma that you have gone through. So those facts to be considered will be a bit difficult for court unless the court is focused on other evidence, say of a psychiatric nature or the medical doctor's evidence on this person, to ascertain the delictual liability. But of course, if parties anytime want to settle the case on the payment of compensation, and the withdrawal of certain properties that they have given, court will always recommend that as settlement is better than going to trial.
A bit of a, well, we're running out of time, unfortunately, but I want to ask you specifically with your experience in the field as well, sir. With all of the understanding you have how individuals actually approach this area, specifically aggrieved parties, what's some advice that you can give to individuals that are probably watching this educational program in order to understand what the key steps should be if one is facing a situation where there is a breach of promise of marriage? What are the key things that individuals should be vigilant of?
Now we see a lot of marriages of the parties being abroad, specifically males in different countries like Australia, England, America, and the females who are here who are also educated trying to get married to go overseas. So in that sphere, the relationship before marriage is a very short period of time. It's by email, WhatsApp messages, Skype, things like that. That is not being humanly together. If you are humanly together for a couple of years, at least 2 to 3 years, you will know that you cannot put on a face before your partner. So I advocate the system that the parties should be very close to each other in the same country and going out regularly together. That will stop any breach of promise of marriage. Because what happens is you put advertisement and you call for applications basically to get married, and you suddenly find out that though he has all the educational qualifications and the criteria, Catholic or Buddhist or whatever, height and all that, when you go to actually live, height is not a problem, religion is not a problem, your thinking is only a problem. So know your thinking, you should be acquiring a friendship with that person for a considerable length of time.
All right. Unfortunately, that is all the time we have for this discussion. I believe that's the perfect note for us to, unfortunately, have to leave off on this specific topic. Thank you very much, sir, for taking the time to try and explain this very vast area and help the layman better understand exactly what the legal responsibilities are in that field. Thank you so much for your time, Mr. Ian Fernando.
Thank you, Anuradhi, for giving me this time. I hope I have delivered the lecture to your satisfaction.
Thank you once again, sir. All right, well, we leave you tonight with the words of Friedrich Nietzsche. It is not a lack of love, but a lack of friendship that makes unhappy marriages. That's all we have for you tonight. You can always rewatch by catching us on our YouTube page, and we always value your opinion, so please share your thoughts and feedback with us through email at feedback.adncenglish@derana.lk or by WhatsApp at 076 805 7933. Thank you very much for watching. Have a good night.